Yes, Mr. Christie.
Honorable Chief Justice, Honorable Justices of the Supreme Court of Canada, I always am honored to be able to speak on these issues, but on each occasion I have come here, I always take the time to check at the front of the building for the two statues that are situated there. And on one side is Justice, and on the other side Veritas. And it's my submission that Veritas and the pursuit of Veritas requires the conflict of discriminatory opinions, and that essentially, particularly in regard to religion, this is an essential freedom in the pursuit of what some people might regard as divine truth, and some others might regard as offensive religious belief. And for this reason, it's my submission that although the case revolves around the facts particularly unique to this case, it cannot be denied that it has implications for freedom of religion, and indeed that the courts have found at each instance where this issue has been addressed that indeed Mr. Ross's freedom of religion is essentially touched by the order. And I think my learned friends have all admitted that it is essential to justify the order under Section 1 of the Charter. Some have said that it does not involve freedom of religion, only freedom of expression. In my submission, I'd like to draw your attention, if I may, to the suggestion that it does involve freedom of religion, that the order of the board does not say that it does not involve freedom of religion, and any reasonable understanding of what took place would affirm that it is essentially a case about freedom of religion. It might be wise then, if I might, to just directly go to the judgment both of the board and of the courts below to point out that I am not merely asserting something, as I will say my learned friends have asserted without really evidentiary foundation, but I will submit that the evidence of the board, if we could, my ladies and my lords, look at volume 27 again, it's clear that the tribunal dealt with the issue of what was being expressed. And at page 5053, line 25, or shortly thereafter, it was said by Mr. Bruce, quote, "It should be noted that there was no evidence presented by Malcolm Ross that his religion required him to write in the manner that he has written. His writings suggest he is putting out some religious conviction, but there was no direct evidence of this and no argument made as to his beliefs meeting the tenets of any particular religion." Further on, he says at 5054, line 23, "It can also be argued that freedom of religion has its limitations. When religious beliefs take the form of an attack and condemnation of those following another religion, this passes well beyond a legitimate freedom of religion and the protection otherwise provided by the Act. In such a case, it would not be a question, therefore, of balancing individual rights." I pause to interpose this submission that freedom of religion is not subject to the Human Rights Act of New Brunswick. In fact, the Charter supersedes any suggestion of such limits, and in fact, this case engages the Charter, and it is therefore a very important case. The learned gentleman, Mr. Bruce, went on to say, "Religious freedom is generally not viewed as entitling one to interfere with the rights of others. And an essential part of my submission will be that at least all monotheistic religions are discriminatory in their belief. That one cannot assert the belief in one true God in one way as a Jew, one way as a Christian, and one way as a Muslim without conflicts that are inherently discriminatory, in that they say and they affirm that this, for example, in the case of the Christian religion, I am the way, the truth, and the life. No one comes to the Father but through me. Now, I'm not asking one to believe it, just to simply accept that it is the position of the author of the Christian religion. Judaism does not regard Jesus Christ as the Messiah. Islam, for its position, regards Allah as the true God and Muhammad as his prophet. So these are antithetical religions, and it is inherently necessary if freedom of religion is to have any real meaning that discriminatory religious opinions must be tolerated. even though they conflict, and even though they might condemn an opposing point of view.
Christie, what I don't understand in your position, the freedom of religion, your client is totally free to practice his religion. The question is he free to express his belief, which is rather freedom of expression. I have a difficulty with the freedom of religion, to be frank. In this particular case, he's totally free. Nobody prevents him from following his religion if it is a religion. But what about...
if it is a religion, my lady?
Yes, if it is a religion, I don't know. I have no particular knowledge of that.
Yes.
But, to me, it seems to be only freedom of expressing his belief and propagating his belief.
Well, what if his religion, my lady, says he's supposed to preach the gospel to every creature, that he has an obligation to fight evil where he sees it? Then indeed it's not only his religion that he must hold and believe, but he must also speak out. And indeed, I would submit there are many among us who consider themselves Christian to believe it is part of their duty to speak their mind on matters of this world and speak out in condemnation of what they regard as evil. That is perhaps an essential part of some religions, not necessarily all. But if we were to pick and choose between religions and say, I don't like yours, I like this one, then I think the courts, human rights tribunals, and the government, indeed, would be turning our society into a state in which genuine religious freedom could really not exist. It is no value to have freedom of religion if you cannot have freedom to express that religious belief. And to say that a teacher, for some reason, has a different standard of religious freedom than any other citizen because they are teachers, is to set up a category of religious freedoms based on occupations, which in my submission will slice this freedom into nothingness. What then would be the case for a policeman? Someone could say, this policeman has said something against my religion. I cannot feel discrimination-free in approaching this policeman, or this lawyer, or this engineer, or anyone with a position that has some authority. Now, I know the arguments.
But what is discrimination?
Discrimination?
What is discrimination?
It should be limited. It should be viewed as an act, treating someone differently because of race, religion, and ethnic origin, or other prohibited ground of discrimination, not to have an opinion that might criticize, for example, sexual orientation. The day that freedom from discrimination means that you cannot express an opinion that is a discriminatory opinion, we may as well check our minds at the door, and perhaps the statue should be removed from the word veritas. We should have put some political correctness standard.
Limit as far as you're concerned.
In terms of expression, there's one limit, the criminal code. And indeed, that criminal code has so far given exemption to the bona fide expression of an opinion upon a religious subject as an absolute bar to prosecution. And if a man can say, in a free society, and I say free because also democratic, but if a man or woman or child, for that matter, can say in a free society a religious opinion that is discriminatory, so is anyone else.
In your view, a teacher can teach anything to the children in that sense?
Not at all.
Well, there is a limit there. It's not criminal. I'm just wondering where you put the line, draw the line.
Thank you very much for the focus of your question, my lady, because that's essentially what I'm trying to distinguish. The on-the-job activity of proselytizing is prohibited, has been prohibited, because the workplace should be free of indoctrination, and especially in a public school. I've never, nor has my client ever been accused, I've never advocated the suggestion that a teacher can take their position to indoctrinate a religious opinion.
Well, why do you stop there then, Mr. Christie? Why do you stop there? Well, if you say that it is part of one's religious belief to engage in what would be called discriminatory or hate propaganda, then why? Well, that's the case.
It's not hate propaganda if it is the bona fide expression of religious opinion. It is not, by definition, even in the criminal code.
Then
so
why
there is no other definition.
Why would the classroom then be the limit to that, if that's the expression? If that is the expression of the opinion of the teacher, his belief, to use our words, his sincerely held belief, then why would the classroom cut that off?
Simply because the employer has the right to dictate the terms under which the teacher teaches. And the employer, being a secular school system, has determined that the religion of no denomination or creed will be taught. That is a matter of his position as an employee. Not a matter of he has accepted the limitation by accepting the contract of employment whereby he does not teach his religious views. That's simply a matter of accepting the conditions of employment. My client accepts that.
So you don't regard off-the-job conduct of any kind. For example, if the teacher would go naked in the streets,
yes.
That would be off the school conduct, and that wouldn't be any. That might be an expression. There's nothing criminal. Let's say he puts a little something on, so there's nothing criminal in it. So where do we draw the line there again? An off-job duty.
It's very, indeed, my lady, I understand. It's very simple. There's no constitutional right to take your clothes off. You have a legal.
It may be considered as expressive.
Well, if it could be viewed, and contrary to my learned friend Mr. Kuttner, I say the American authorities are not all over the map on this. Religious freedom does not generally espouse, it may be unless you were a Doukhobor, perhaps at times, it does espouse taking your clothes off. But indeed, if it were a bona fide religious expression, and if, as a matter of fact, if a court could find that, as they have found, for example, in the draft dodger cases in the United States, they don't have to agree with the tenets of an established religion. But if it is a bona fide religious reason, perhaps it is expressive. I'm not defending my client for endeavoring to take his clothes off. I'm defending the right to express what no one has suggested for a moment was not at least the traditional Christian position. And I can back that up with reference to the quotations that are attributed in the writings of my client. And I notice that nobody dares to bring to your attention any suggestion that my client's views and expressed opinions were not at any time, or not certainly at one time or another, the position of certainly gospel writers, church fathers, others in the Christian religion. Now, if that be the case, the only thing of which my client is guilty of is perhaps having antiquated or atavistic, I think my learned friends have referred to as atavistic religious views. Well, if it is considered impossible to express atavistic religious views, we have established then in the Human Rights Tribunal a form of inquisition of what is acceptable religious standards. And if it isn't entirely clear from what Mr. Bruce has written that he has set himself up as the authority in what is an acceptable religious opinion or the tenets of a religion.
But Mr. Christie, sorry,
yes,
from here.
Thank you. The lights are so bright I can hardly see you.
I know, it's difficult.
I feel like being interrogated, all right.
First of all, if we could just get back for a minute to discrimination. Mm-hmm. If, for example, we won't take Mr. Ross's statements, but say a fundamentalist of the Islamic faith said, all Christians are evil. Mm-hmm. All Christians should be punished and killed. Mm-hmm. First of all, would that be discriminatory under Section 15?
I've always contended that Section 15 is not intended to act as a sword against opinions, but only against acts. So I would say no. It's a discriminatory opinion, but not a prohibited opinion if the act is interpreted properly.
Then your position, as I take it, would be so long as it's a sincerely held belief that of a religious nature.
Let me say a bona fide opinion upon a religious subject.
All right. That on that basis, a discriminatory statement can be made without compunction.
Well, you took it one step further than just a discriminatory statement. If I heard your example, it went so far as to counsel the commission of a criminal offense, namely murder, I would think, killing someone.
Well, then
if we took that out...
Back it up. Take out the killing.
Yes. That Christians
are evil. All Christians are evil.
Yes. That's
and steps should be taken to...
To what? I'm sorry?
To acknowledge that they are evil.
To acknowledge that they are evil? That certainly could be, presuming an honest belief, could be a bona fide religious opinion. And to prohibit it, then you must prohibit all. unless you're to set up some tribunal, such as Mr. Bruce, to assess ones he likes and doesn't like. And in the United States, they have said unless you do not favor or disfavor one, you cannot favor or disfavor all. The minute you set up a standard by which you will say, these are acceptable religious opinions, but those are not, then I suggest, my Lord, that freedom of religion becomes really freedom of politically correct religion.
Well, Mr. Christie, let me put it this way. What is it that makes that statement about Christians being evil a bona fide religious opinion?
Honest belief there's ample authority for what constitutes that. One particular one that I was going to address, my Lord, if I could, is the case of the draft dodger who said, I don't believe in an established God, the official version of religion, but I believe in ethical premises. And the courts had to struggle with what is a genuine bona fide religious belief, and they said ultimately, and it's repeated over and over and over again in United States Supreme Court cases, it is a bona fide belief in the existence and authority of a higher ethical power. And if you go further and say it's a tolerant belief, you've effectively said you can't have belief. You can only have syncretism. And that's a word I wanted to refer to because it's a very interesting word, a useful word. It means the equality of all beliefs. And in the end, that means no beliefs. Because you can't hold one belief as sacred when all others are equally valid, especially if the one belief you hold might be Christian or Jewish or Muslim. You can't just say, oh, well, they're all right. Because if they're all right, yours must be wrong. Particularly where it says it is the truth, at least as I understand, monotheistic religions do say. I hope I've tried to address
well,
that.
I understand what you're saying. I have some trouble with it. But
well, I must say, my Lord, that Mr. Justice Kieran's once told me you have a right to explain your position, but not to talk so long as I must accept it. And I accept it.
No, that's fine.
All right. I'm hopeful that my Lord understands. I'm sure it's not necessary that you agree, but I hope you agree. Anyway.
Mr. Christie, I think we touched a moment ago on what is at the heart of this case, and that is the capacity or an obligation of the school board to maintain your client as a teacher.
Right.
And it's to what extent it's permissible for the school board to make certain requirements or impose certain requirements on its staff or teaching staff. So that is what is, to my mind, at the heart of this case, and not as to your client's religious beliefs and ability to express himself.
Well, may I
there is no restriction whatsoever on that, as I understand it, if your client is not employed by the school board.
Well, my Lord,
or does not seek employment by the school board.
It should be remembered, my Lord, that the school board had no contentions against Mr. Ross. They found no fault in him. He did his job exactly as they directed, and it wasn't their desire to dismiss him. And contrary to what has been said here, they did not find he had poisoned the environment. There's no evidence they found he had poisoned the environment. They found it was difficult, because of the controversy, for them to do their job, which is quite a different thing, like the heckler's veto. They did not find that he failed to do his job, and it was not their desire to fire him. So you have, in fact, the intervention of a state authority, the Human Rights Commission, directing the employer to do what the employer said we have no reason to do.
Well, you're just putting it at another level, but the problem remains the same, and that is the capacity of your client to meet the requirements of a school teacher or to be a role model. Now, the school board has a certain authority, apparently, under the New Brunswick legislation, but the Human Rights Commission also has a certain role to play in these matters under the New Brunswick legislation. So I don't know that that makes much difference. We're just looking at different agents of the state, so to speak.
Well, let's look at the substance then. You said that he has a duty to be a role model. The opinion that he is not a role model can only be premised on one thing, and that is that his expressions, which have been really quite slandered here and referred to as anti-Semitic, and vehemently hate literature, not one word of which has ever been shown to be anything but authentic, genuine Christian belief. And there is no authority to say that it's anything else, except the mere assertion of my learned friends. And is that all it takes? There was not a single witness called of any religious authority, if there is any, to say that his opinions were unfounded Christianity or unhistoric Christianity.
But is that the test?
Well, I'm suggesting
is that
no.
the test for parents who have to confide their children to public schooling?
No, if he conducted himself in a discriminatory fashion in the course of his duties, within the scope of his employment, they have every reason to be concerned. But if he happens to be a Jehovah's Witness and stand on the street corners and preach that the Catholic Church is the whore of Babylon, or whatever he might want to say, they have no right to object to that.
I mean, the parents have no right over the education that their children may receive.
Neither the school district nor the parents have any right to dictate the religious expression of a teacher.
Well, they have no right to dictate his religious expression, but do they have a right to choose who their teachers may be?
And had the school board made a decision that it had deleteriously affected his work, then they might so determine, if they could establish that. But that was not their determination. In fact, witnesses called by the school board showed that not one single discriminatory effect was ever found after a very serious investigation. Ms. Doucette and the school psychologist, whose name escapes me, evidence in the transcript, were fully conversant with all the facts of Mr. Ross's school and where he taught and how he taught, and what they did investigation on all the students. No parents are complaining in the sense of people who had contact with Mr. Ross.
Well, I hope you don't leave it there, because, I mean, Mr. Finkelstein read us from findings by the board that the school board accepted that there was a poisoned atmosphere.
No, I don't think that there is any finding of that, my Lord. If there is, I'd be very surprised. My understanding was that the finding was that the circumstances had made it difficult for them to do their duty due to the controversy. I know he said that the school board admitted there was a poisoned atmosphere. And even if I'm wrong in that, I don't think I am, but if I'm wrong in that, how can a school board, a human rights commissioner, or a court determine what religious views are poison? Poison can only exist if the religious views are bad religious views.
Well, they become poison at the stage that they hurt other people.
There's no evidence of that.
What was the finding?
The finding, all right. We could go on to find where Mr. Bruce said that it might have certain impacts. He never said that there was any evidence that it did. And I think in my factum, if I'm not mistaken in regard to this, I refer specifically to what he said, and I direct your attention, if I may, to the exact references to that. Yes, I managed very fortunately at paragraph 48 to find what the board found in my factum, and it says the board held, this is page 5064, line 36 to 5065, line 6, the board held, in the case of a teacher who has proclaimed the discriminatory view publicly, the effect may adversely impact on the school community, it may raise fears or concerns of potential misconduct by the teacher in the classroom, and more importantly, it may be seen as a signal that others view these prejudicial views as acceptable. That is not, in my submission, anything more than speculation. It's not a finding of fact about any existing reality, and in order to justify as a substantial and pressing concern in my submission, which is the Section 1 justification, there has to be more than the possibility of harm. There has to be the actuality, some evidence of it.
There is something, I thought, at page 5067, the conclusion of the board has no hesitation in concluding that there are many references in those, or in these published writings, and comments by Malcolm Ross, which are prima facie discriminatory against persons of the Jewish faith and ancestry. And it goes on, but doesn't that indicate it's a conclusion?
Yeah, that makes my point, I think, if I may, my lord. It says he finds there were the expression of discriminatory opinions, but does that say that he found any effect in the school or in the school district? I say not at all.
Well, it does go on to say, but to hold those of the Jewish faith and ancestry in contempt as undermining freedom, democracy, and Christian beliefs and value. Malcolm Ross identifies Judaism as the enemy and calls on all Christians to join the battle.
Well,
if it holds up contempt, I would have thought that that was an indication of discrimination and a finding by the board.
It's a finding by the board, their judgment of his views. Yes.
Well,
there is no, may I just finish this?
Yes.
Yeah. There is no finding that his views had any effect upon any student anywhere in the school district or had ever been communicated to any student. Nor in my submission is there a finding that those comments are untrue or not a bona fide religious or opinion upon a religious subject. And to simply say they are discriminatory and to make the determination, which I'm suggesting Mr. Bruce is not competent to make. I suggest Mr. Bruce, a human rights commissioner, is not competent to decide whether religious views that are discriminatory will hold persons of another faith in contempt.
Well, yes, that's what, Mr. Christie, that is your position, that it couldn't be discriminatory if the remarks are of a nature pertaining to a sincerely held religious belief. But if the board has found that they are discriminatory, and I thought that's what we were dealing with at the time, did the board make an actual finding? I know your position is that it cannot be discriminatory if the remarks are the relating of a sincerely held religious belief.
No, I would like to make a clarification here. The board can make any opinion it likes about what it thinks of opinions. These are a determination and assessment of a religious opinion, and it finds that it's discriminatory, right? In my submission, to constitute a Section 1 justification to eliminate freedom of religion, it has to do more than suggest the existence of a discriminatory opinion, and it has to, in my submission, have evidence of some real, pressing, and substantial concern caused by actual effect, not simply to say that he expresses a discriminatory opinion, and therefore, whether it has any effect or not, we take that as a basis for holding that we can override his constitutionally protected right to freedom of religion simply because it may raise fears, and it may be seen, and it may adversely impact. I suggest, unless you're going to remove any obligation to establish a Section 1 justification on real, substantial, and pressing concerns, unless you're going to do that, then this evidence is by no means close to being far enough.
Mr. Christie, isn't there evidence of harm or finding of harm at 5069 where it is stated the Board of Inquiry has no hesitation in concluding that the public statements and writings of Malcolm Ross have continually, over many years, contributed to the creation of a poisoned environment within the school district, which has greatly interfered with the educational services provided to the complainant and his children?
That is, my lady, a religious judgment.
Well, it's a finding of some harm, and this court has often stated that freedom of religion may not be extended to situations where the religious expression is creating harm toward others. This seems to be a finding of harm.
It's an opinion of what is and is not poison. If Brian Bruce was to say Malcolm Ross's religious views are poisonous, which is exactly the effect of what you've quoted, would he be qualified to do that?
Well, it does say greatly interfered with the educational services.
If his religious views are not poisonous but truthful, then can it be said that he has no right to express them?
Well, I imagine that's something that could be argued before the board, but it was up to the board to find whether this was causing harm to the delivery of education services. And I'm just saying,
I see.
is this not a finding that we at least have to deal with and apply the legal tests to?
Well, I'm suggesting, lady, that there are some findings which are not just findings of fact, but are expressions of opinion. And to say that my views are poisonous, for instance, could be called a finding of fact. But in my submission, it is actually expression of opinion, particularly if they happen to be religious views. And to do that is beyond the competence of what I thought was a human rights tribunal dealing with acts of discrimination. Unless they're endowed with the capacity.
I would have thought that's exactly what the board is set up to do, to make findings in the view of controversial evidence and say, this is the way I see it. And then once they've done that, the ability of superior courts to interfere with that is, if they've done it properly and on the right grounds, is greatly limited.
Well, if you take the position that to express a judgment on someone's religious views is a finding of fact, and that an appointed person who is neither impartial nor obliged to be impartial, nor are they under any judicial independence, if they can determine what is considered by them to be poison, and if you take the view that they're entitled to do that and no one can interfere with it, well, then I can't argue with that.
Well, he is impartial. I think he would be sworn, the board would be sworn to be.
No, I don't believe so, my lady. There's no statutory obligation to take an oath.
Mr. Christie, just further behind supporting that finding, we were directed to page 5036. In the last paragraph, the evidence shows that the school board decided in March '88 that Malcolm Ross had inhibited its ability to manage and direct the educational process and had detrimentally affected its reputation. It also noted a negative impact on Malcolm Ross's reputation and his perceived inability to foster an atmosphere of tolerance as a public school teacher. That's finding number one. Page 5039, I'll give you the second one and then you can comment. At the top of the page, further, the school board again informed Malcolm Ross that some of his past actions and comments had affected the administrative operation of Magnetic Hills School and had caused some parents to be concerned about general safety.
Where was that, my lord?
The top of the page, sorry.
At 5039?
5039. And it caused some parents to be concerned about general safety and the attention being brought to the school. So there's two findings that...
Yeah, they're findings of the school board. And a moment ago I heard the statement made that it doesn't matter whether it's findings of the board or findings of the school board. Let me say in answer to the second that those concerns, which if one was to look back on them, was based upon the media coverage and the controversy created, and not in any way a reflection of anything that Mr. Ross...
Those are findings. The question we have is there no evidence for that decision maker to rely on to make that finding? Is it totally unsupported by the evidence? Is that what you're arguing, or you're arguing something else? Because we have to deal with those findings that the board came to. If there is evidence for them, then it seems to me that we have to take them as findings.
Well, if you take them as findings, they are findings not of the they are findings of the school board. And if you take them as findings, the school board found that they did not render Mr. Ross incapable of being a teacher, because it wasn't the school board's desire to remove him from the class. If those are findings, then I would trust that you would accept that the findings did not include the finding that he was incapable of being a teacher, because they didn't remove him. And if I go back to 5036, you say the evidence shows that the school board decided in March of 1988, is that a decision of the board or of the school board, that Malcolm Ross had inhibited its ability to manage and direct the educational process and had detrimentally affected its reputation? Is that something to do with the writings of Malcolm Ross, or is it something to do with other circumstances? It doesn't decide that issue. I mean, is Malcolm Ross to be punished for the effects of the media upon the school board? If that's the criterion, then I guess what it amounts to is if your views are controversial enough that the media creates a storm for your employer, then the result is you lose your freedom of expression. And that's, of course, a political reality, but I'm not sure it should be a legal reality, because it means really that you have constitutional rights to be popular and acceptable to the media. That's all it means. It says it also noted a negative impact on Mr. Malcolm Ross's reputation. I suggest that's irrelevant. It's not a finding that affects his constitutional rights, and his perceived inability to foster an atmosphere of tolerance as a public school teacher. Is that a Section 1 justification? Is that a substantial and pressing concern for the elimination of his freedom of expression of religious values? Being his perceived inability is a perception that's all that's necessary? Of course, that's what Mr. Bruce said. And as I said over and over again, all he ever says is it may, and it might, and that's good enough. And furthermore, he says, it really doesn't matter. It never tries to apply the Charter anyway. So the Charter was never applied by the lower tribunal. And when it came to the subject of religious freedom, I want to suggest that, and I would ask your lordships and ladyships to consider, that the judgment of Mr. Justice Crean which is referred to at sorry? Yes, thank you, milady. I appreciate that. But I was going to ask if we could to look for 5103. And I'm asking consideration and acceptance of this finding because it had never been considered before, because the Charter had never been applied before, that is at the tribunal stage. At line 10, His Lordship Justice Crean says, I do not think there can be any doubt that Malcolm Ross's freedom of conscience and religion and his freedom of thought, belief, opinion, and expression have been impinged by the finding and the order of the Board of Inquiry. This is the first time the Charter was ever applied, the first time a Section 1 analysis was ever done. And then he goes on to say, the argument that Mr. Ross's writings do not reflect religious expression does not bear scrutiny of his published writings. The Board did not come to an opposite conclusion, even though it questioned the legitimacy of his religious views and the existence of a religious tenet that required him to publish them. The Court of Appeal said at 5112, Mr. Ross, that's line 25, Mr. Ross argues that Western Christian civilization is being undermined and destroyed by an international Jewish conspiracy. As Crean J. noted, there can be little doubt that Mr. Ross sincerely holds these views. And then further on, if I may, at 5120, bottom of the page, line 30, there can be little doubt that as Paul Crean J. found, Section 2A, B, and C of Professor Bruce's order offend Mr. Ross's 2A and B constitutional rights to freedom of conscience, religion, and expression. For publicly stating his sincerely held views, Mr. Ross was penalized by being prevented from continuing his teaching career. At the bottom of that page, Paul Crean J. examined the order in the context of charter guarantees and found that Mr. Ross's freedom of expression and religious belief were violated by Professor Bruce's order, but concluded that the portion of the order that removed Mr. Ross from classroom teaching could be saved by Section 1. Page 5123, line 30, it must be remembered that Mr. Ross's activities outside the school had attracted Mr. Addis's complaint. The evidence does not disclose that Mr. Ross ever used or contended that he was free to use his teaching position to further his religious views. In my submission, it has not been denied at any stage and should not be denied here in the submissions of my learned friends that there was an expression of bona fide religious opinions from which there was no real and direct evidence of any effect. Albeit there's a finding they were discriminatory opinions, which I'm submitting is beyond the jurisdiction of a one-man appointed tribunal. As I say, unless these people are endowed with some theological authority, and I suggest it really is quite absurd to suggest that my friends can substitute their opinions and be just as effective. I mean, if Mr. Ross had criticized the Christian religion and Christians had complained that he was anti-Christian in his opinions, I would submit it's unlikely we'd be here, but in any event, that demonstrates how absurd it would be. I mean, in 1925, Mr. Scopes was accused of teaching in school the subject of evolution, and I remember my friends referring to evolutionists. Well, they might be abhorrent views. They might be views that would demonstrate contempt for Christian views. But I would simply say that if they're not expressed in the context of the school, the employer can't have anything to say about it, and they should be free to say that. As we, I'm sure, would agree, that's their freedom of non-religion or irreligion. And nobody in this society, our secular society of today, would make the slightest suggestion that they shouldn't be a teacher because they don't believe in Jesus Christ, or that they say bad things about Jesus Christ, or they say that Christianity is a foolish religion, or that all religion is foolish. Is this court going to sanction, by upholding the order of the board, that a one-man appointed tribunal has the authority to prohibit the private expression of religious opinion? I suggest it be a very dangerous precedent, because I used to make the slippery slope argument. I was here with Keekstra and said, in time, it'll be only a matter of time before teachers are not restricted in what they say in class, but restricted in what they say out of class. And well, I'm here now, I don't know how many years later, and that's exactly what we're arguing about. And if teachers, why not policemen? And if policemen, why not lawyers? And if lawyers, why not engineers? Where do we stop? Well, there seems no limit, except a reasonable one, of letting people express their religious beliefs, discriminatory or not, on their own time in a tolerant society. If tolerance doesn't mean tolerance for beliefs, does it demand we have no beliefs? In my submission, that's the result. I started out by saying if we posit that there was a religion that demanded that one proselytize, that one speak out on issues of moral concern, if one posited that that religion's founder claimed divine authority, can one then say that to express those views, because they are discriminatory, I submit they are discriminatory views, does then one say one cannot therefore be a teacher? And it seems that the suggestion is arising that although you might be able to believe that, you should never be allowed to say that. And the end result is, what is the point? What is the point of believing? You really can't practice your religion, but you can simply hide in a corner and hope that somehow the light will shine. Well, with all due respect, the United States is the only country in the world, I might say, that has grappled really with the issue of freedom of religion. Europe is not a society in which freedom of religion was anything meaningful, traditionally. It was not a free society in terms of religion. There were established churches and great religious conflict as a result. And why should we, having adopted the concept of a limit on government's power over freedom of religion, not look to the United States, who've had this experience? Why should we regard ourselves as superior to them in our experience when we've had none on the issue of religious freedom? I would like to take the time to refer, if I may, to what the United States experience has been. I tried to prepare a little book of authorities. I gave one to my friends. It's the green volume. Recently, the United States Supreme Court had to consider whether freedom of religion might even offend to the point where the Santeria religion could practice animal sacrifice, and it held that they could. I won't go into detail, but there was a number of pronouncements that bears some consideration, because where do you look for authority on freedom of religion cases? I mean, Britain doesn't limit or limit government power to restrict religion. It has an officially established religion. We can't look to Britain on this issue. So do we just ignore the United States? In my submission, that would be unwise. If I could briefly turn to page 17 of that case, the authority there, the tab 1, I highlighted the portion that said the neutrality of a law is suspect if First Amendment freedoms are curtailed to prevent isolated collateral harms not themselves prohibited by regulation. Sorry.
On a minute,
I apologize.
no fault of yours. So it's tab 1.
Yeah, page 17.
Page 17.
I tried to highlight the parts that I want to refer to, and I tried to do so in my friend's fact authorities as well, but it's the part that says the neutrality of a law is suspect if First Amendment freedoms are curtailed to prevent isolated collateral harms not themselves prohibited by direct regulation. And I would submit here that how that applies is that discriminatory religious opinions are not prohibited. They might be considered collateral harms. They're not real harms. There's no substantial evidence of real harm. If this order is not neutral, so that all religious expression, no teacher should speak about any religion. If you want to go that far, then it's neutral. But it's not neutral. It attacks one specific religious belief and specifically targets Malcolm Ross's beliefs. And in support of the position that the law should have been upheld, of course, the proponents at page 20 argued exactly what my learned friends have really affirmed here. They said this community will not tolerate religious practices which are abhorrent to its citizens. Well, the Supreme Court said that's not the criterion for religious freedom. My learned friends find my client's opinions abhorrent. If that's the category, or if Brian Bruce does, if that's the criterion of Section 1 limitations, or if that meets the test of Section 1, where's the pressing of substantial harm? Where's the proportionality? Where's there anything but subjective opinions? These people, of course, many people find animal sacrifice abhorrent. But if religious freedom means anything, it means religious freedom to people we don't agree with. If I might turn to page 24. A law burdening religious practice that is not neutral or of general application must undergo the most rigorous of scrutiny. To satisfy the commands of the First Amendment, a law restrictive of religious practice must advance interests of the highest order. Now, if absence of discriminatory opinion is of the highest order, the end result of that is that all opinion, really believed opinion, is...
You give us this case as an example of an animal sacrifice, and you were quite specific in giving this. This is part of a religious, if you like, tradition. Mm-hmm. In this case, tell me where preaching opprobrium, preaching enmity, is part of the religious, if you like, tradition of your client.
Thank you. Well, my client relies on a document which he claims has divine authority. That's part of his Christian religion, that the Bible is divinely revealed. So you asked me a specific question.
I want you to ask two questions. I know what your client says. Tell me where his religion says that.
Well, that's exactly what I was going to do.
Because this case tells us that the religion in question says animal sacrifice is part of it. Mm-hmm. Tell me what.
Mm-hmm. Well, although this was never raised as being important before the tribunal, where if there was anyone said it wasn't a Christian belief. But let me just say, for example, this document that my client refers to, the Bible, is full of references to those who are what referred to as ye stiff-necked and uncircumcised in heart and ears. Ye do always resist the Holy Ghost, as your fathers did, so do ye. Which of the prophets have not your fathers persecuted? And they have slain them which showed before of the coming of the just one, of whom ye have been now the betrayers and murderers. You have received the law by the disposition of angels, and ye have not kept it. When they heard these things, they were cut to the hearts, and they gnashed him with their teeth. For example, in Acts 23:12-13, when it was day, certain of the Jews banded together and bound themselves under a curse, saying that they would neither eat nor drink them, that they had killed Paul. Thessalonians 2:14-16, for ye, brethren, became followers of the churches of God in Judea, which are in Christ Jesus, for ye also suffered like things of your own countrymen, even as they have of the Jews, who have both killed the Lord Jesus and their own prophets, and have persecuted us, and they please not God, and are contrary to all men, forbidding us to speak to the Gentiles, that they might be saved, to fill up their sins away, for the wrath is come upon them to the uttermost. Revelations 2:9. I know thy works and tribulations and poverty, for thou art rich, and I know the blasphemy of them which say they are Jews, but are not, but of the synagogue of Satan. Revelations 3:9, behold, I will make them of the synagogue of Satan, which say they are Jews, but are not. But
Mr. Christie, if I can interrupt,
Right.
I thought the question was whether there was a doctrinal belief in the 20th century that required your client to make statements of hatred about particular groups, and I don't see in those quotations from the Bible a response immediately to that question.
Well, I'm awfully sorry. I thought that it did refer to the biblical origin of my client's views about the Judaic religion, which is antithetical to
I
Christianity.
had thought the question was slightly different than that
Okay,
myself.
if you, I didn't hear the term 20th century. I heard the term, is there anything in the Christian religion which is the basis for this? And that's what I meant to address. And I if you wish me to address the subject of what 20th century beliefs are, you see, the point is, nobody has ever suggested that, nor was there any evidence, that my client's views were not Christian. They, in fact, the courts have taken the view, and Mr. Bruce did not find that they were other than a bona fide religious expression of the Christian religion, albeit perhaps not shared by all Christians. So I'm not sure how to address your question. Maybe I've missed the point. I apologize. But in all honesty, if what I have said is consistent with the origin of the Christian religion as my client sees it, how can the courts take the view that this is not legitimate Christian opinion? As simple as that. And I mean, yeah, there's no comparison with religious sacrifice of animals. I'm not saying we're here to measure religions. We're here to tolerate, hopefully, religions, whether we agree with them or not. And I can refer to cases where the position of the courts in the United States, which have had to deal with these issues a lot more in my submission, is other than Big M Drug Mart, I don't know of any case in which religious expression or the general views of this court have been expressed on a religious subject. But the American courts have had to deal with this quite a bit. And
see, you are looking at your watch.
I thought perhaps an hour would be... Sorry?
Were you thinking of a break, or do you think you can conclude your submissions?
I'm sure I can conclude my submissions, but a break would certainly help.
Why don't we break for 10 minutes?
Thank you kindly, my lord.
Or recess for 10 minutes. Yes, Mr. Christie.
Thank you, my lord. If I could perhaps add some clarification to my response to my lady, Madam Justice McLaughlin, I think it's correct to say that the entirety of my client's writings on the subject of the historic church in Judaism is covered in Chapter 7 of the book Spectre of Power, which is at page 73, and in a number of instances, keeping in mind that this, volume 23, it's volume 23, and it extends, actually Chapter 7 extends from 4158 to some distance on, and what in effect it does is explain the origin of his view that Christianity and Judaism are antithetical in their view of the most important person in history. At least that is what his belief is. And when I say he gives historic background, I think I'm being accurate in saying if you look at the footnotes and citations, he quotes from everything from the doctrines of the church in the past to the teachings of the church fathers, the councils, particularly to say that the views of Jews and Christians on the issue of who is Jesus Christ diverge and are diametrically opposed. And it becomes an important question to someone who is a Christian, and his view was that we should not view there as being a religion such as Judeo-Christianity after the time of Christ. There is not a common denominator of belief on the most important issue. So I hope it would be fair to ask that if you're going to take a consideration of whether what he writes has any basis in Christianity, two things should be considered. First of all, that it is a legitimate Christian belief that it is your duty to preach the gospel to every creature, and secondly, that the historic church has for a long time, and perhaps not so much in modern times, but for a long time viewed Judaism and Christianity as opposed. Now, it may be that this is a religious belief that is unique to a few people, but it cannot be denied that it's historically based, and it may not be a widespread belief, but that in the history of analysis of religious freedom, at least in the United States, has never been a basis to prohibit or even restrict the expression of religious opinion. And before you this day, there has not been one case that indicated anywhere the ability to restrict the expression of bona fide religious opinion from teachers in the United States or Canada. And that is why I think my friends have acknowledged this is a case of first instance. And there aren't too many people who will take the flack and the heat that Mr. Ross has, but there'll be far fewer if the consequences are that they cannot be teachers. And the bottom line is that if Mr. Ross has perhaps valid religious beliefs, perhaps his religious beliefs are valid. Imagine that. My friends would have maybe blasphemed against a genuine Christian. If it was possibly true, well then how unfair could that be, that he could not be a teacher? Why shouldn't he be a role model if what he says is true? And
Mr. Christie, it seems to me we're leaving the true debate somewhat, because it's not the beliefs that are at issue before this court. This is not a theological or canonical court, but it's the attitude towards others and the peace in society and peace in the schools. So it's not the belief that's of any interest, to me at least, but whether the attitude towards the other person and the incitation that may have. In other words, is it the preaching of contempt and an incitation to contempt, and perhaps further. But in the case of your client, what seems to be reproached to him is not so much the contempt, but its effect that there has been a poisonous environment as a result of that. You have raised the issue that there was no direct evidence as to that. That is one aspect of the case. Mm-hmm. But what we're looking, and the finding was to the poisonous environment. And of course you said, well, yes, but then are we to be all victims of the media? Well,
I must resist the oversimplification inherent in that statement, if I may, because I have tried to emphasize that the determination of what is or is not poison, if we're talking about religious beliefs, is a religious judgment, and it's beyond the scope of...
Well, do you see, that's my problem with your statement. It's, even if the belief is poisonous, we're not really concerned with that. Well, we're concerned, I'm sorry, Mr. Christie, we're concerned with the poisonous environment. Well, that was the reproach that the inquiry board made, that there was a poisonous environment that was the result of, or to which your client's writings or TV interviews had contributed. Now, that is a fact of life that the board has to deal with. And it has to deal with in terms of choosing the people to whom it will confide and to whom their parents will confide their children. Now, there's some things we control and some things we don't control, but the law has to try and maintain peace and order in society, and that's the level at which I think I operate. Anyway.
Well, that's your opinion, my lord. I don't know what I can say. If there was a question, I'd address it, but I take there is no question.
Is that the point that we have to address, to my mind, is whether there was evidence to support this finding of a poisonous environment.
Well, there wasn't.
Well, I know that is your submission.
Well, no. Can my learned friends, have they pointed to you to any evidence of a poisoned atmosphere other than the opinion of Mr. Bruce that it may be so, and his view that it was so? Excuse me. He says it was poisoned, all right?
And he had no doubt about that.
Oh, well, fine. He can make the judgment without evidence, then, I take it. and that's satisfactory.
Well, that's your statement that there was no evidence.
Well,
but of course,
okay,
there was certain evidence
I take the word
we're
poison.
all aware of.
Okay, I take the word poison to mean something which has an effect. If you want to use the word poison in the abstract, it is the judgment of someone that this water is poison. I drink it, it's poison, but it has no effect. You can call it poison, but do you have any evidence for that? Is that a substantial and pressing concern if it has no effect? Where is the effect? After innumerable inquiries in the district of any possible effect, every shred of evidence indicated not one person was treated differently in Mr. Ross's school by Mr. Ross or felt differently in Mr. Ross's school by Mr. Ross. And the only evidence was that then of Yona Addis and her cousin Lee Lampert. And what were they? They're talking about another school where Mr. Ross never was, never appeared, not one word that any of his writings ever was read by anybody there. And because someone there says something about Jews, Mr. Ross should be blamed. Now that is not logical or rationally connected to any of Mr. Ross's writings. So I'm saying if you want to justify it under Section 1 as a rationally connected, demonstrably justifiable limit, there's no reason how you can say, I mean, court, if you mean poison, as I say in the abstract, I don't like this, therefore it's poison, well, there's just no way you can answer that. But it isn't a Section 1 justification, in my submission.
Well, I think that's the issue. Now that you've addressed the issue that's before us.
Then I'm grateful to your
As
lordship.
I see it.
Indeed, well, I'm very grateful to your lordship for pointing that out to me. Let me say that in my learned friend, I think Mr. Richler's submissions to you, he quotes from the finding of the tribunal as to what Mr. Ross's writings say, and that's at page 2 of the factum of the, I think, the Canadian Jewish Congress. And Mr. Ross is saying, it is indeed the Judeo-Christian society our society has fought against for years, a society under the control of a Jewish-controlled mass media, Jewish-controlled international finance, and now a Jewish-dominated Christianity, where every evangelist who appears on our television spews out the same old line: the Jews are God's chosen people, so we must support them no matter what they do. I believe many of the evils in our land stem from the fact we've denied the kingship of Christ in our society and have allowed those who hate the Lord to rule over us. Well, I don't suggest anyone agree with that, but surely one can identify it as a religious expression of concern. Reject it, but don't say that it's not a religious expression of concern about a religious topic. And if so, what is the measure of the poison if there is no effect demonstrated in the workplace? Can therefore we take the view that a human rights tribunal can make a subjective determination of poison without effect and condemn a legitimate religious expression? Well, my submission is that ought not to be the case. And when people write books, with all the opportunity there is in a free society to write answers, to suggest that you can thereby legitimately take away their job without any effect on their job or workplace renders a lot of people in legitimate concern for freedom of expression. Not too many people know the realities of this case, but they will know it if this tribunal, this honorable court, decides that the law of the land legitimizes the opinion of one man, Brian Bruce, to determine poison without the requirement of any demonstrable effect. That would be a very serious departure from the existence of the Section 1 burdens that used to be upheld. If I could turn to tab 4, the United States courts have continually referred to this document, the remonstrance of Madison in the Virginia legislature, and it's repeated over and over again in the cases, so it's not just 1785. These issues have been with us longer than the 20th century, and what is said before is sometimes worth repeating. At page 300 it was said, it is unalienable because, that is the right to freedom of religion, because the opinions of men depending only on the evidence contemplated by their own minds cannot follow the dictates of other men. It is unalienable, and of course in those days they weren't very correct about saying and women, but in every event it is unalienably so because what is here a right towards men is a duty towards the Creator. It is the duty of every man to render to the Creator such homage and such only as he believes to be acceptable to him. This duty is precedent both in order of time and degree of obligation to the claims of civil society. Further down, we maintain, therefore, that in matters of religion, no man's right is abridged by the institution of civil society, and that religion is wholly exempt from its cognizance. And that indeed it is said that the majority may trespass on the rights of the minority, which in my submission is what's inherently wrong with the situation here, where I stand alone representing an individual's right to freedom of religion, and all the others stand on the premise that because they take the view his opinions are wrong, that simply by asserting it, simply by Brian Bruce saying so, that's good enough. Well, if we have that view of freedom of religion, heaven help the minority. It says further, above all, are they to be considered as retaining an equal title to the free exercise of religion according to the dictates of conscience. Whilst we assert for ourselves a freedom to embrace, to profess, to observe the religion which we believe to be of divine origin, we cannot deny an equal freedom to those whose minds have not yet yielded to the evidence which has convinced us. If I could just refer to the next remonstrance, that was remonstrance number 5, and this was a bill to establish religion in a sense for teachers of Christianity. It said, because the bill implies that the civil magistrate is a competent judge of religious truth, or that he may employ religion as an engine of civil policy. The first is an arrogant pretension falsified by the contradictory opinions of rulers in all ages and throughout the world. The second is unhallowed perversion of the means of salvation. I would submit that the civil magistrate in this case is Mr. Bruce, and the view that he can use religion or its restriction as an engine of civil policy, namely tolerance, is wrong because it arrogates to an individual, or pretends to, the power to define what is an acceptable religious tenet. If I might read briefly on, it is moreover to weaken in those who profess their religion a pious confidence in its innate excellence and the patronage of its author, and to foster in those who reject it a suspicion that its friends are too conscious of its fallacies to trust to its own merits. In essence, those remarks and following were quoted over and again in the United States to show that the government should not favor or disfavor religious opinion. If I could just refer to tab 5. And in this case, it was the state of Michigan versus Emmanuel Baptist Preschool. If I could turn to page 5, it says, the elements of the standard, and this is where I think the standard of the United States has been expressed somewhat. The first inquiry is whether the free exercise claim is rooted in religious belief. A religious belief must be based upon more than purely secular or philosophically based personal concerns to be protected by the First Amendment. Religiously motivated conduct need not stem from adherence to the tenets of a particular religious organization, however, to enjoy the protection of the first free exercise clause. While a court may inquire into whether a religious belief is genuine or sincere, it should not decide the truth or reasonableness of the belief. United States and Ballard. And reading further there, the determination of what is a religious belief or practice is more often than not a difficult and delicate task. However, the resolution of that question is not to turn upon a judicial perception of the particular belief or practice in question. Religious beliefs need not be acceptable, logical, consistent, or comprehensible to others in order to merit First Amendment protection. In sum, the court must accept an organization's good faith characterization that its activity is grounded in religious belief because it is not within the judicial canon to question the centrality of a particular belief or practice to a faith or the validity of particular litigants' interpretations of those creeds. And I cited later on the case of Hernandez. It's there. If I could just turn to tab 6 and refer very quickly, if I could, to this court's statements in the case of Big M Drug Mart. It's tab 6. If I could turn to page 407. I would like to submit that Salmer, at the bottom of the page 407, although in the issue in Salmer versus the City of Quebec and AG Quebec was the validity of a bylaw of the City of Quebec attacked by a member of the Jehovah's Witnesses, forbidding distribution in the streets of any book or pamphlet without permission, the judgments in the case are wide-ranging. There is a passage in the judgment of Ranjay touching upon religious freedom, found on page 319, and it's quoted, "From 1760, therefore, to the present moment, religious freedom has in our legal system been recognized as a principle of fundamental character, and although we have nothing in the nature of an established church, that the untrammeled affirmations of religious belief and its propagation, personal or institutional, remain as the greatest constitutional significance throughout the Dominion is unquestionable." Page 409 and refers to Chaput and Romaine. It's quoted as saying, "The conscience of each is a personal matter and the concern of nobody else. It would be distressing to think that a majority might impose its religious views upon a minority, and it would be a shocking error to believe that one serves his country or his religion by denying in one province to a minority the same rights which one rightly claims for oneself in another province." If I could just refer to page 417. The general statement is made, which I would like to suggest is the basis of my client's position. A truly free society is one which can accommodate a wide variety of beliefs, diversity of tastes and pursuits, customs and codes of conduct. The essence of the concept of freedom of religion is the right to entertain such religious beliefs as a person chooses, the right to declare religious beliefs openly and without fear of hindrance or reprisal, and the right to manifest belief by worship, practice, or by teaching, dissemination. But the concept means more than that. Going over, one of the major purposes of the Charter is to protect within reason from compulsion or restraint. Coercion includes not only such blatant forms of compulsion as direct commands, which is what Brian Bruce's order is, to act or refrain from acting on pain of sanction. Coercion includes indirect forms of control, which determine or limit alternative courses of conduct available to others. My submission, others can publish religious tracts, so should Mr. Ross. And then it says, freedom in a broad sense embraces both the absence of coercion and constraint and the right to manifest beliefs and practices. Freedom means that subjects to such limitations as are necessary to protect safety, public safety, order, health, or morals, or the fundamental rights and freedoms of others, no one is to be forced to act in a way contrary to his beliefs or his conscience. Now, if there are any more exceptions to this freedom of religion, it will cease to exist, but if we are to take those words broadly, public safety can mean the freedom from controversy. And that's all there ever was in this case, a controversy between Mr. Addis and Mr. Ross. Mr. Addis was after Mr. Ross from the time his child was 2 years old. She confirmed that in the evidence. And it's in my factum as to where she does. Now, if an individual with a religious grievance or axe to grind against a teacher can use his child's later as a means of complaining when nothing was done that affected her in any way by the person that her father disliked, you can just see how readily this weapon can be used to destroy people whose religious beliefs somebody else doesn't like. And a teacher is very vulnerable to attack for having a controversial religious opinion with no effect at all in the classroom. How nice it would be to target some teachers that I remember only too well with some grievous complaint that had no effect at all in the classroom because my father might not like their views and maybe I never met them. But can you see how dangerous such an order can be, such a rule can be? Because teachers are people too. They have a right to as much religious freedom as anybody else in their own time. See, I am really quite concerned about the suggestion that your status in life can determine different categories of charter freedom, charter rights. Teachers and public officials have charter rights that are this big. Laborers have bigger ones because they don't count anyway. Because nobody listens to them, they have no authority, nobody's influenced by them. Well, I'd like to think that equality of rights means that whether you're a teacher, you're a prime minister, you're a laborer, you're a truck driver, your religious freedom is the same, and if it isn't clear, we're not going to know where the boundaries lie. And if it's different for every profession, we're going to have to go to the Ministry of Truth, or, like Truth Canada, to find out what's a legitimate religious expression, and thereby be restricted from saying anything else. But really, such a society would be ridiculous. And yet, that's the direction we're headed, with all these limitations, exceptions, I mean, how many more? There could be nothing left of this religious freedom. As I said, it's sliced to bits. if it can be taken that any offense taken by an opposing religious group can justify the view that therefore, because they make enough noise or they have enough influence or they're angry enough, that it's causing a damage to public safety or order. It says further, the Charter safeguards religious minorities from the threat of the tyranny of the majority, and in my submission, that's what's wrong with Mr. Bruce's order. He's trying to do the politically correct thing. In fact, there's no suggestion he's not exactly what he says he is. You know, there's very few cases in which I've seen a judge who puts himself down and signs himself as Brian Bruce Consultants Limited. It doesn't give me a great deal of confidence, nor to my client, in the judicial impartiality of someone appointed on an ad hoc basis who can exercise their own religious judgment about the people that come before them and is in the style of cause as Brian Bruce Consultants Limited. It does tell me a certain amount about his relationship with his employer, the government. He's not an independent judicial officer. And the danger is that such a person can do what was done here. He can say, I find you're poisonous. And that's it. That's what happened. And Brian Bruce may be the nicest man and want to do the best for everybody. No doubt he is. That generous, kind-hearted person doesn't like to hear offensive religious views. But is he qualified for that reason alone to say you're poisonous to a man who may be a sincere Christian, maybe even right for all we know? And you know, what amazes me is the general statement of Mr. Justice Dixon in this case at 427. If it was to be taken literally, maybe I take it
7 of what?
I'm sorry, my lord. Big M drug mark, tab 6. Sorry. At 427, he says these words, which if they mean what they say, and maybe I'm simple, but it means to me that this cannot happen. What happened to Mr. Bruce should not happen, to Mr. Ross should not happen. It says, with the entrenchment, at the bottom of that page, of the Charter, the definition of freedom of conscience and religion is no longer vulnerable to legislative incursion. Well, this is even less than a legislative incursion. This is a discretionary power from a statutory body. I conclude, therefore, that the definition of freedom of conscience and religion incorporates freedom from compulsory religious observance, not only in accordance with the purposes and traditions underlying the Charter, it is also in line with the definition of that concept as found in the Canadian jurisprudence. And Salmer is the best example of that. RAV versus Minnesota is a case in the United States Supreme Court, which I've referred to once before here in the Keekstrid case, and perhaps your lordships and ladyships are familiar with this, but I would like to submit that when it came to what in effect is a Section 1 analysis, they take a much more restrictive view than was taken years ago in the Keekstrid case, and they deal with the exact problem that Keekstrid dealt with. And it said at page 2, if I may, and I've highlighted this as a Section 1 argument or analogous to it, quote, the ordinance is a narrowly tailored means towards accomplishing the compelling governmental interest in protecting the community against bias-motivated threats to public safety and order. And that was the justification used for the hate law in Minnesota, and that was struck down primarily because, as was held at page 6 in the majority opinion, page 4, highlighted, the government may not regulate use based on hostility or favoritism towards the underlying message expressed. And if I could just go over to page 6, the First Amendment does not permit St. Paul to impose special prohibitions on those speakers who express views on disfavored subjects. And they just said basically that it was beyond the capacity of the legislature under the First Amendment of the United States to prohibit speech on disfavored subjects such as race, religion, or ethnic origin. Now, I concede that it doesn't stand the present test of this court's jurisdiction or jurisprudence, in Regina and Keekstrid, but with the development, and I'm hopeful to say that the development from the Keekstrid case to the Zundo case, and goodness only knows, it may indicate a view that Section 1 justifications require a pressing and substantial concern, and I hope that means some real, serious evidence of actual effects, but if it does, then perhaps we should look at the United States as having already answered the question which was unanswered in Keekstra number 1, which was whether hate crimes are prohibited under the Constitution of the United States. They are now so prohibited. The law, and I mean the laws are prohibited. The acts are not criminal in the United States if RAV versus Minnesota is to be taken at its face. I was, in answer to my learned friend's quotation from Hannah Arendt, I was interested to suggest that the criticism of Judaism is neither immoral nor wrong, and that in fact it is now a modern trend to view Zionism, Judaism in perhaps a different light, and that Hannah Arendt, who wrote in the 50s and 60s and sometimes in the 70s, is no more valid than Israel Shahak, whose view is, and I found it quoted at page 12, which unfortunately the number doesn't come out. He said, I strongly believe that anti-Semitism and Jewish chauvinism can only be fought simultaneously, which is to say, perhaps legitimate criticism of religion has a value in the understanding that results, and that tolerance is not achieved by silencing criticism. In effect, all it does is increase antipathy, and therefore is no great benefit to society. Now, if I could just turn to the case of Edna Ballard, which was in the United States Supreme Court, tab 9, and I could look at the headnote, perhaps, which is highlighted as the first item. It says, all considerations concerning the truth or falsity of the religious beliefs or doctrines professed by the accused are by reason of the constitutional gravity of freedom of religious belief properly excluded from consideration. I might say that my learned friends make much of the suggestion that this is remedial and not punitive. And I find that a very hollow submission. I submit to you that it has no real significant meaning. There are many people who would rather go to jail than lose their job. There are many teachers and many lawyers and many doctors who would rather go to jail than stop being a lawyer, a doctor, or a teacher. And to say that because it's not done by a court with the rules of evidence, with the rights of the presumption of innocence, with the right to exclude hearsay, as such as it used to be, is not to say that these are not serious harms. To take away a person's professional capacity is viewed by most people as extremely punitive. And all the more so when you don't have the opportunity, as appears to be the case here, to have the Charter of Rights available to you, because it was never applied by Brian Bruce, as if it never existed in his ruling, as if freedom of religion never existed. Well, I'm going to submit that there's really no distinction between using the Human Rights Act as a sword to basically slay your political adversary and a criminal prosecution. If anything, the damage to Mr. Ross's career, his reputation, his life, has been more serious than if he was charged with impaired driving or if he was charged with a lot of other serious offenses. So there's, in my submission, is pretty artificial to pretend that this is not punitive. And if it wasn't punitive, why was it, as Mr. Justice Auger asked in the argument, he said, if it wasn't punitive, why was it suspension without pay? Good question. It's very clear that Brian Bruce had a very strong animosity towards Mr. Ross's religious opinions. He's made a judgment without evidence of effect on his own perception. He's subjectively just effectively judged Mr. Ross's view. What he knows about religion, or any of us for that matter, maybe nothing. And yet, he has the power, according to my learned friend's arguments, to simply say that is poison. And I am very troubled. My client's extremely troubled by that. I'm sorry to repeat myself.
The poison argument you...
yes, indeed. I get tired of poison myself.
Your point is that there is no evidence that it had a poisonous effect.
Or any effect. Any real substantial effect, I'm saying. I mean, when I say effect, I mean there has to be some evidence of a real event that occurred differently, something that really happened. And it doesn't... And I know that my friends may reply... It's
not up to you to point to an absence of evidence. It's up to you, the opponents, to indicate to us, show the evidence.
And I was going to say, my Lord, that probably they will refer to Yonah Addis's feelings.
No.
Which they may argue that isn't... And I heard my friends argue, you can't ask a reasonable standard of an adult of a child. Well, that argument is a dangerous one in my submission because, for one thing, If you don't expect a reasonable standard, then it's a totally subjective standard. And the young lady said she felt afraid, but then she said, I had no reason for that. She said it herself. And I would submit that that is not a reasonable limit. If I could just refer briefly to Ballard at page 73, a quote is there expressed, it's highlighted to say, the law knows no heresy and is committed to support no dogma, the establishment of no sect. If I could refer to page 88, I highlighted the portions there from a case cited above, and this is in that judgment. It embraces the right to maintain theories of life and of death and of the hereafter, which are rank heresy to the followers of Orthodox faith. Heresy trials are foreign to our Constitution. Men may believe what they cannot prove. They may not be put to the proof of their religious doctrines or beliefs. The religious experiences which are as real as life to some may be incomprehensible to others, may I interject, may be even considered hateful by others. Yet the fact that they may be beyond the ken of mortals does not mean that they can be made suspect before the law. Many take their gospel from the New Testament, but it could hardly be supposed that they could be tried before a jury charged with the duty of determining whether those teachings contain false representations. The miracles of the New Testament, the divinity of Christ, life after death, the power of prayer, are deep in the religious convictions of many. If one could be sent to jail because a jury in a hostile environment found those teachings false, little indeed would be left of religious freedom. The fathers of the Constitution were not unaware of the varied and extreme views of religious sects, and the violence of disagreement among them, and of the lack of any one religious creed on which all men would agree. They fashioned a charter of government which envisaged the widest possible toleration of conflicting views. Man's relations to his God were made no concern of the state. He was granted the right to worship as he pleased and to answer to no man for the verity of his religious views. The religious views espoused by the respondents might seem incredible, if not preposterous, to most people. But those doctrines are subject to trial before a jury charged with finding their truth or falsity. Then the same can be done with the religious beliefs of any sect. When the triers of fact undertake that task, they enter a forbidden domain. And I know they're going to tell your lordships and your ladyships that this is for a charge, a criminal charge, and there's a vast difference. But Brian Bruce, if anything, is less competent to give a fair trial to Mr. Ross than a trial in a criminal court, where he would have the defense, if it was a hate crime, as my friends throw that word around so carelessly, if it was hate literature, as they've said, he would have the defense of the bona fide expression of a religious opinion. That was never even considered by Brian Bruce. And so, if anything, his rights were less, the dangers to him more, and his religious liberty was absolutely overridden. At page 1157, if religious liberty includes, as it must, the right to communicate such experience to others, it seems to me an impossible task for juries to separate fancied ones from real ones, dreams from happenings, and hallucinations from true clairvoyance. Faith means belief in something concerning which doubt is still theoretically possible. That from Mr. Justice Jackson of Nuremberg fame. But if I may just briefly submit that these observations are quite germane to what went on before Brian Bruce. It is far more dangerous to have the capacity and the power that Brian Bruce had to do virtually what he liked than to have a trial before a court where some semblance of evidentiary rules, some semblance of an obligation to impartiality legally exists. It could be overturned on the facts. You see, as has been said to me many, many times, Mr. Christie, we can never review the facts. Well, if it was a criminal trial, that would be possible, and I could demand that there be evidence. Well, the powers of Mr. Bruce were so great that it's been said over quite often here that it doesn't matter. We can't take a different view of the facts, and of course that was the same position taken in the courts below. Sager was a case of conscientious objection in which Tim
teaching against the war or something.
He was claiming a religious exemption.
Yes.
And he claimed no belief in a supreme being, but if I could just refer briefly to that judgment of the Supreme Court of the United States at page 748. at the bottom of that page, in light of his beliefs and the unquestioned sincerity with which he held them, we think the board, had it applied the test we propose today, would have granted him the exemption. We think it clear that the beliefs which prompted his objection occupy the same place in his life as the beliefs of a traditional deity hold in the lives of his friends, the Quakers. In essence, then, I could turn over to page 752 and conclude with this remark. In sum, I agree with the court that any person opposed to the war on the basis of a sincere belief which in his life fills the same place as a belief in God fills in the life of an Orthodox religionist is entitled to exemption under the statute. None comes to us an avowedly irreligious person or as an atheist. One is a sincere believer in goodness and virtue for their own sakes. His questions and doubts on theological issues and his wonder are no more alien to the statutory standard than are the awe-inspired questions of a devout Buddhist. I say that to simply support the submission that whether a subjective determination of disagreement existed, at least in the United States, is not viewed as in any way justification. In conclusion, on this issue of the authorities of the American courts,
there's left the Amish case with the eighth grade students.
Yeah, wherein in fact they were allowed the exemption to what would otherwise simply be a usual standard requirement for public education, and some of the comments which I would perhaps like to suggest are some value.
Just that we read all of this already,
right.
You know.
I'm sorry?
Fairer cases.
Indeed. Well, then there's not much to say, because I only want to say that if it's true that there is a right to religious dissent, a right to religious conflict of opinion, it can hardly be said that that right can be different for teachers and for Malcolm Ross in particular without any demonstrated consequence in the workplace.
I think they all make the same point.
I think so.
In different contexts. Mm-hmm. One's war, the other one is education, compulsory school attendance that violates religious beliefs, and they all make the same point.
Well, my submission would be that in the United States, at least, the courts wisely, and I would like to suggest this might be helpful to and useful to view as applicable here.
Well, this court has frequently, since the inception of the charter, gone to the U.S. Experience because there's nowhere else to go. Cruel and unusual punishment and equality, and so we're not adverse to the idea of having a look there. In fact, many of us changed our library when we in '82.
Well,
certainly we'll look to American authorities in this area, and albeit also to European authorities if there are some. Mm-hmm. Maybe
when my Lord, it's found in the decision of the Board of Inquiry and is quoted at 5067 to 5069. There's a number of statements by Mr. Bruce.
6-7.
I have enumerated in my factum in regard to the in reply to David Addis at page 19 and page 20, my paragraph 99. The board there quotes Mr. Ross in the newspaper article and quotes him to say, "My work is not disguised as Christian as Dr. Israeli insists, but is completely faithful to the spirit of the Christian faith from earliest Christian times to at least our post-Auschwitz Christian church, when the Jewish infiltration of top offices in the Vatican and elsewhere led to the sorry state of the Christian church and Christian society today." And then he says, and it's quoting Malcolm Ross again, "It is indeed the Judeo-Christian society," etc. I've read that. But further on, "My whole purpose in writing and publishing is to exalt Jesus Christ and to inform Christians about the great satanic movement which is trying to destroy our Christian faith and civilization." If that were anything but the sincere expression of Mr. Ross, there should have been some evidence to that effect, and when it is clearly before the tribunal, so clearly so that the tribunal quotes it as part of the judgment, in my submission, the tribunal is basically being willfully blind to the existence of a claim of bona fide religious faith and does not consider it. It cannot be said that it ignored that pronouncement. It quoted it, and it quoted it against the person who affirmed that belief. Nothing could more clearly demonstrate that the tribunal is taking a subjective view in doing what it did. My learned friends referred to the UN Declaration of Human Rights. For whatever effect that has, I would like to reply by saying that that declaration it says it shall promote understanding, tolerance, and friendship among all religious groups. It does not say all acceptable, liberal, or ethically relativist groups. And since there are groups that take positions religiously that are quite antithetical to each other, it must mean that tolerance means tolerance of extreme opposition, condemnation. Or else it would simply say tolerance, in effect, equal to syncretism, the equalization of all religions, which equalization is a popular term in this country, but it is not, in my submission, one applicable to religious differences. When sincerely held, they constitute the most important differences that human beings can hold, and if expressed without violence, without advocacy of violence, and there's none of that in Mr. Ross whatsoever in any of his writings, then they are legitimate religious dissent.
I guess this case raises issues that are somewhat similar to the case of Dagenet, where you have competing charter rights, and that the Section 1 analysis might have to be somewhat a little bit different than the Oaks, or at least there's a little twist put to it.
Well,
Are we talking about coexistence, cohabitation of different religions, and the expressions, freedom of expression as regard the religion of others, and as regard one's religion? Aren't we not a little bit in the situation, I put this to you, on an injunction, the balance of inconveniences?
Well, that would be
where, as I think Mr. Justice Gaultier said, no one is stopping your client from holding beliefs and expressing them, except to the extent where the expression of those beliefs sort of impinge upon the freedom of religion of others. And aren't we not in a balance of inconveniences a little bit to say, well, their freedom of religion requires that you might have to pull in your clause as regards your tolerance of theirs. I don't know.
The danger with that, it would be very easy among people who have no strong views to advise both to moderate their opinions and thereby to achieve peace. And the balance of convenience may at times resemble that perhaps wise and good faith, well-intentioned view. But in matters of religion, if sincerity and genuine conviction combine to produce differences, it would seem that applying a balance of convenience would be a dangerous practice unless there's some...
How do you deal with two competing charter interests?
Well, what is the other...
In Dagenet, it was freedom of... It was the freedom of the press as regards freedom of the right to a fair trial. And one had to give in a little bit to the other. And
there you had Section 7 rights, as Your Lordship, I think, said.
Yes.
Okay, but I don't see any other constitutional right in issue here.
Well, there's a freedom of religion of the Jews.
Well, there's no suggestion whatsoever that the ability for Mr. Ross to express his condemnation of the religious position of Judaism has any restriction on Jews from applying.
Well, it incites people to be against Jews.
Well,
because of their religion, and therefore it impinges upon their freedom of religion. It incites to maybe intolerance, or intolerance. I don't want to pass judgment, but I may say acceptance, non-acceptance of Jews, qua Jews, and surely this impinges upon their freedom to be Jews. Well, Cyrus in 480 BC acknowledged to everyone the right to be a Jew.
Indeed, and there's no suggestion that my client has ever said that someone couldn't be a Jew.
Well, no, but he says it's awful to be one.
He says it's wrong. He says it's morally wrong.
I know, but my point is that where do we balance? We're not running a speaker square. We're trying to manage a country.
Well, then maybe there better be a principle that says we stay out of the arena of religious opinions, because the minute you step in, you're going to be balancing an awful lot of people's freedom out of existence. And
that's the problem of a pluralistic society.
But the United States position, which has dealt with this a long time, is that they don't take a part in the arena. They don't start saying, well, is it more convenient for, is it better for this person to be free or that? In effect, though, there's no suggestion of any claim of restriction upon Yonah Addis, David Addis, or anyone to practice the Jewish religion. There's the
relation to the Human Rights Act. It's not competing constitutional issues. Or their parents claim that violation under Section 5 of the Human Rights Act.
But never...
It's not that they can't practice their faith. Feel discriminated against because of their religion.
Never before has the Human Rights Act been used in this way, to allege that the expression of an opinion is discriminatory, constitutes discrimination. And I've looked as hard as I could. There's never been that suggestion before. And if it constitutes discrimination to have a view that's critical of a religion, or, for example, sexual orientation, which of course will be the next issue before this court, someone will criticize sexual orientation, and someone will go before a Human Rights Commission, and we'll be through this process, I suppose, again. But if we pronounce that opinions are not the subject of human rights legislation, we're not involved in arbitrating opinions, but acts of discrimination. That was the original intent, in my understanding.
The argument that you haven't really answered, I'm still here.
I apologize. This sound is confusing. I'm sorry.
Yes.
To what extent does anyone have the right to practice their religion way as to make others feel discriminated against, i.e., in the case of a teacher, the classroom, young student, any student, or publicly castigate the type of religion leaving, that student feel that he or she is going to be harshly treated by the teacher, publicly stated that the belongs is wrong and evil, conspiracy against the rest. How does the student reconcile her position when that teacher has held those views publicly, although not in the classroom?
She can feel quite confident that the authority of the school board has established that there will be no acts of discrimination in the classroom of any kind. And if there was an act of discrimination...
She knows.
Knows or believes?
Believes.
Yes.
Person, because of writings and statements made. Absolutely no regard for her faith, whatever it is. That student be confident that the teacher is going to treat her as entitled to be treated under the Human Rights Act in New Brunswick or Nova Scotia.
I don't know whether she can feel that confidence. Subjectively, I can't tell you, but I can tell you this.
What's the difference in that and being turned down in a restaurant because you're a Muslim?
There's a world of difference because for one thing, there's a real effect. All you've asked, all you've suggested is necessary to constitute a limit on freedom of speech in your first example is the feeling that there might be discrimination, a feeling of possible discrimination. That feeling, if that feeling is a justification to silence someone.
Well, it has to be a well-founded feeling, but you're talking about someone who's an author of books.
Well, a well-founded feeling that one is going to discriminate is hard to justify in relation to the absence of any act of discrimination unless you can allow speculation, which is, in my submission, a dangerous justification for a Section 1 limitation. The feeling that he might, or the feeling that, for example, I might come into this court with the feeling that someone is strongly opinionated against me. That feeling may or may not be well-founded,
Let's suppose,
but I can't rely on that.
Let's take your example, and I'm not going to
As a
prolong this
reasonable
much
apprehension
longer.
of bias.
Well, take your example. Let's suppose a member of this court wrote a book, wrote an article about Mr. Christie. Said that they didn't like the kinds of cases he argued, like him personally. Now, would you say for a minute that you wouldn't have some apprehension that that person was going to be partial or partial?
Well, that puts it on a pretty personal level.
Well, of course it does, but the students are on a personal level.
But a criticism of Judaism in the light of its difference to Christianity is not a personal criticism of an individual. There's no reference to any...
And I don't want to go to the transcript, but you saw where one child testified that we ought not to go to that school because Jews.
No, that's the place where Mr. Ross teaches, is what she said. I can only say that to be a reasonable apprehension of bias, there has to be more than a subjective and unjustified fear. And now, you said the example of a direct statement that you don't like Doug Christie and his views or his whatever. That would seem to be a direct example of a demonstration or pronouncement of bias. But it's hardly, and it's not constitutionally protected either, for that matter, other than freedom of expression. It's not a religious opinion, as far as I know. It would be my submission that there is no demonstrated effect and no demonstrated bias other than a religious bias. And if you could take the view that, for example, I take the view that, however, that judges are supposed to be more impartial than a Christian. A Christian is not supposed to be impartial on religion. A Christian is supposed to advocate, preach the gospel, and to be a public defender of their faith. You know, it is a little different. And if a person takes seriously the obligation to proselytize their religion, then I don't think that the subjective feelings that they don't agree with my religion or that they don't approve of my religion is a justification to silence them, unless they do something to disadvantage you because of your religion. It surely should be that a real act is the only pressing and substantial concern that society is entitled to invade it upon religious belief, because otherwise the invasion is based upon antipathy. You know, and antipathy can be manipulating our feelings. I mean, I might have no reason for an apprehension of bias, but because I happen to, nobody says anything, nobody does anything to me differently, but because I feel that you don't like me, that could be almost paranoid.
That's the test that's applied with respect to bias. You don't have to show that there's any effect. It's the appearance.
But there has to
the appearance of partiality that might lead the person who is dependent on a decision to believe that they won't get justice. Now, isn't that what's argued here? Is your client makes these statements from which you can infer that he has an animosity towards Jews. In the classroom, very often students are dependent on his exercise of discretion, which it may not be apparent that he is biased, because you don't know what's in the person's mind when he makes a decision to give this mark or that mark, or to take any other action. And therefore, there would be a loss of confidence, and the school board has an obligation to promote an atmosphere of tolerance so all students feel that they're treated equally. Isn't that the case that's put against you?
It may be. A reasonable apprehension of bias, however, is only a danger in areas where a judicial function is performed, as far as I understand it. A teacher is not disqualified from teaching because they have a reasonable apprehension, for example, of political bias, a reasonable apprehension of ethical bias, a reasonable apprehension of religious bias. Unless they do something, you can't demand that high standard of a teacher that you would have, for example, of a judge who's going to decide a case. I mean, judges have a tough enough time, and I've heard some judges write about the difficulties of being entitled to express opinions, but surely the whole of society doesn't have to measure that high.
It's not limited to judges. It's any person who has a power to make a decision that affects somebody's rights.
Whoa. Anybody who has a power of decision to affect somebody's rights has no right to express a discriminatory opinion outside of their...
Cannot display a reasonable apprehension of bias. If there's a reasonable apprehension, it doesn't apply to only judges. It applies to many administrative tribunals from the lowest to the highest. Anybody that decides anything is subject to this rule. And it may be novel, but perhaps a teacher is in that position. If a teacher supposing the teacher made statements outside the class that he had an animosity towards a particular group, and whenever he had the chance, he gave them the lowest possible mark, but nobody could prove an actual effect in the class, would that not create the apprehension that there was not the atmosphere of tolerance and impartiality that a teacher is required to display in the classroom?
Well, that might be a reason for discipline from the employer on the contractual relationship, because he's obliged to be impartial in the manner he administers his authority. But
and if the employer didn't do that, then there would be a basis for saying the employer was discriminating against those students who were affected, wouldn't there?
All I can say to that is that not only is that, to me at least, a novel proposition, I find no authority for it, but furthermore I submit it's a dangerous proposition because it extends, if it extends to the subject of religion, it means anyone in a position of authority who expresses an opinion upon a religious subject which is not impartial publicly would be deemed unfit for that job. And I would think that would, as widely as you extended the example, and quite rightly I'm sure, would mean that really the effective expression of religious opinion would be restricted to those who are unemployed.
Well, we're dealing with teachers at the moment. We can't cover the whole waterfront. I agree. We'll deal with the other officials when we get the case.
When the politically correct bring them here.
No, but we're talking about state action in this because we have to come within the confines of the Human Rights Act and what its scope is.
Well, the state action is not the action of Malcolm Ross. It's the action of the Human Rights Tribunal. And the Human Rights Tribunal is the intolerant and discriminatory one, discriminatory against his religious views. I mean, there is not a shred of evidence that he exhibited any religious intolerance or bigotry or lack of impartiality in class. And after all the inquiry, one can only say that the finding, as you point out many times, of poison is based upon what? The subjective opinion of Leona Addis at another school, and her perception, which she acknowledged came from two sources: her father, who hated Ross since she was 3, and the media. That's exactly what it says in the evidence. Not from Ross, who she never met. And may I say that nowhere in any of the finding of the tribunal is there one shred of evidence that Malcolm Ross says that Jews should be treated differently. In fact, if you look at Chapter 7, his view is that the prayers for their conversion is his solution. Now, everybody scoffs at that, but assuming that he believes that's for their salvation, then is he entitled to that religious opinion? Is that a discriminatory opinion in the sense that he would disadvantage, treat worse, be cruel to anyone because of religion? I suggest not. In effect, then, those rules, and I understand that you're asking me these questions because these are answers you have to make this decision. If those principles could be applied, then religious opinions could be expressed by those whose vocation it is, in the sense of being a priest or a religious person, to express them. Laymen really, unless they had no authority, would be unable to express them.
One of the things I want to, when you're recourse to the United States cases, we've said in a number of decisions of this court that, of course, reference to that experience can be limited because the structure of rights and freedoms in our Constitution is quite different. And one of those, I think, differences is not just Section 1, but also Section 27, which comes back to a bit what the Chief Justice was saying, namely that there is going to be, ultimately, in a diverse, pluralistic society, collisions among rights, and that rights aren't absolute, and that somehow one has to find a way of trying to work with these rights in a way that is, for lack of a better word, civilized and sensible. So what does that tell us about the way in which we look at the rights of your client vis-a-vis the rights of others to practice their religion?
Well, I think the reasonable and only practical solution is to take the principled stand that unless an act of discrimination is demonstrated in the conduct of the person, they should not be subject to punitive sanctions such as the loss of their job. To leave it on any other basis seems to me to invite speculation, invite subjective feelings as a reasonable limit to freedom of religion, and a pressing and substantial concern can only be demonstrated, and proportionality and rationality can only be demonstrated where there is some evidence of the act, not of the media or the lady's father or somebody else, but of Mr. Ross doing something in a manner that discriminates against someone because of race, religion, or ethnic origin. In effect, this tribunal has inflicted restrictions not on the school board, but on Mr. Ross. They aren't even here. They don't particularly care. It doesn't affect them. What's the loss of one teacher to them? It costs more to be here than it's worth to them, and the outcome won't affect them at all. It'll certainly affect Mr. Ross and anyone else who dares to express their religious views, rightly or wrongly. So the dangers in my submission of allowing this judgment to have any effect, to keep him out of the classroom or to do something that in effect is punitive, would set a dangerous precedent far beyond the scope of the unique facts of this case to prejudice the freedom of religious expression for anyone in a position of authority. The arguments made to affect a teacher are equally, very moderately changed, equally effective to limit freedom for anyone with any authority, as I think Mr. Justice Sapinka may have asked me about. Maybe I extend that too far, sir, but that's my submission of the danger of the whole process, that this order has no pressing or substantial justification. There is no effect that it really directs itself to, and it is not rationally connected to anything that will remedy the situation. If there was discrimination in Yona Addis's class, or if her father's influence upon her mind affected her feelings, then the solution is to have a public discussion in which the school board articulates its policy and it publicly announces that if anyone offends it, there will be punitive actions by the employer. That is the way to solve this problem, not to punish someone whose words had no effect. And unless there are any questions, I thank you kindly for hearing me. I understand that I will have no right of reply, and I've tried to anticipate some of the arguments, but no doubt have failed, so I will endeavor to be quiet and listen and perhaps hear what the replies are. Thank you very much.
Well, it'll be limited to reply. They won't bring up new matters. If so, we'll let you come back.
Thank you very much, my lord and ladies. Thank you. Thank you for hearing me.